Hello. Tonight, we open an old case file, but one that has never rested. Our first piece of evidence is Exhibit A. You've seen it 1,000 times. It's the classic depiction of an Egyptian couple, carved in stone or painted on a tomb wall. Look at the statue of Menkaure and his queen. He stands rigid, powerful, 1 foot forward. She stands beside him, one arm affectionately around his waist, the other on his arm. She is his equal in artistry, graceful, serene, but she is his shadow. She is the supportive partner, the bearer of children, the keeper of the home. This is the image we have been sold. The Egyptian woman as a beautiful, respected, but ultimately subservient possession. This image is a half-truth, and a half-truth is the most effective kind of lie. The real evidence isn't in the idealized stone of a pharaoh's tomb. It's on brittle, unassuming fragments of papyrus stored in museum archives. They are contracts, court records, and letters from a village of common laborers. And what they say is so radical, so contrary to the world we think we know, that you may not want to be there when the truth surfaces. Before we continue, please like and subscribe, only if you truly enjoy this investigative storytelling style. Tonight's file concerns the lost legal world of Egyptian women. What hypotheses do you have? Do you think they were more or less free than women today? Leave your thoughts. Dim the lights, open your skeptical eyes, and enter the case file. The common fact, the one that forms our baseline assumption, is that the ancient world was a man's world. And this is overwhelmingly true. In ancient Athens, a woman was a perpetual minor. Passed from the legal control of her father to that of her husband, she could not own property. She could not initiate a lawsuit. She could not exist in a legal or economic sense without a male guardian. In Rome, the law of patria potestas, the father's power, gave a husband literal life and death control over his entire family, including his wife. This is the grim backdrop of history. We see the Egyptian art, and we place it against this backdrop. We assume naturally that Egypt was the same. We are wrong. This case file is about a legal system that appears to have been erased from history, an anomaly that shouldn't have existed. The odd, lesser-known detail is that, under Egyptian law, a woman operated as a complete and independent legal individual. From the moment she was born, a woman, in the eyes of the court, was a citizen. This is not an exaggeration. We are not inferring this from poetry. We are reading it in black ink on legal documents. She could buy property. She could sell property. She could enter into contracts in her own name. She could be the plaintiff or the defendant in a court of law. She could write her own will and bequeath her property to whomever she chose. And she did all of this without the need for a male guardian, a husband, or a brother to co-sign. This shatters the subservient shadow myth. The woman in the statue, with her arm around her husband, was not his property. In fact, the legal record suggests it's just as likely that she owned the very house they lived in. Historians still debate whether this extraordinary legal equality on paper translated into social equality in the home. Did the law simply provide a framework, while societal custom, the patriarchy we expect, still ruled the day-to-day? Or was the average Egyptian home a place of relative equality that would look shockingly modern to us? The evidence is contradictory. The official art, made by men, almost always shows men in charge. But the legal papyri, the records of real life and real disputes, show women fighting for their rights and winning. This file is not about what we see in the art. It's about what we can read in the contracts. The art shows us the ideal. The court records show us the reality. And the reality is that the ancient Egyptian woman was not a shadow. She was a person. And as we're about to see, her power was most evident not when she entered a marriage, but when she chose to leave one. That independent legal status we established in Section 1, that a woman was a citizen in the eyes of the court, is the key that unlocks this entire file. Because the true test of that independence is not what happens when she is single, but what happens when she gets married. In almost every other ancient society, this was the precise moment her legal identity was extinguished, absorbed completely by her husband's. In Egypt, her identity was instead codified in ink. The common fact, known to all Egyptologists, is that the act of marriage was a remarkably simple, private, and social affair. There was no grand religious ceremony performed by a priest. There was no state magistrate to sign a license. A marriage was created by a simple public act of cohabitation. The woman, often in a small procession with her family, would simply move her personal belongings from her father's house into the house of her new husband. The moment she crossed that threshold, they were considered married. It was a social, not a religious or state-mandated union. But this is where the investigation pivots from the social to the legal. For a significant portion of the population, this simple act was immediately followed by or preceded by a cold, hard piece of business. We now submit Exhibit B, the SNHT, the marriage contract. We have found these, written on brittle papyrus, and they are not what you would expect. They contain no poetry, no flowery vows of eternal love, no mention of the gods or the afterlife. They are, in essence, the first prenuptial agreements in human history. And they are ruthlessly economic. The odd, lesser-known detail that changes everything is the precise function of this document. It was not designed to bind the couple together. It was designed to meticulously separate their property. The main body of a typical contract is a detailed, itemized list of every single item the woman was bringing into the union. This was her shun, which we might loosely call a dowry, but the legal distinction here is critical. This property, the bronze mirror, the linen tunics, the wooden chest, the donkey, the cooking pots, did not transfer to the husband. It did not become family property. It remained unequivocally her property. The contract served as a legal firewall, stating that the husband was granted use of these items, but he never ever assumed ownership. But it gets even more radical. The contract often details a second list of property, the SP. This was the nuptial gift, a sum of wealth or goods, often silver, grain, or oil, that the husband gave to the wife at the time of the marriage. This, too, became her sole and separate property, for her to manage, invest, or dispose of as she saw fit. She entered the marriage not as a dependent, but as an economic partner and independent shareholder in the household, with her own portfolio of assets, protected by law. Historians still debate whether these contracts were a universal practice or if they were a luxury reserved for the wealthy elite who actually had property to protect. The evidence, however, seems to point to a surprisingly broad use. Many of our best examples come from el-medina, the village of common laborers and artisans. We have the contracts of stonemasons' wives and carpenters' daughters. This suggests that even for families with very little, the principle of a woman's economic independence was so fundamental that it was worth the time and expense to have a scribe write it down. The debate also touches on intent. Was this a progressive move to empower women? Or was it a practical move by the woman's father to protect his family's wealth, ensuring his new son-in-law couldn't squander the inheritance? But in the cold lens of the law, the intent is almost irrelevant. The result was the same. The woman held the economic power. This contract was not just a list, it was a loaded weapon, a legal and financial guarantee that backed up her next and most shocking right. That legal framework, the prenup from Section 2, was not just a safety net for a widow, it was the loaded weapon a woman brought into the marriage. It ensured that her power as a citizen was not diminished. The common fact that historians have long accepted is that divorce in ancient Egypt was shockingly common, simple, and carried no social or religious stigma. Like the marriage itself, it was a private affair. There was no state court to grant a decree, no priest to nullify a sacred vow. A marriage began when two people cohabitated, and it ended, quite simply, when they stopped. This is where the case file veers sharply from the reality of the rest of the ancient world. In most patriarchal societies, the power to end a marriage rested solely with the husband, and in Egypt, a man could certainly do this. He could stand in front of witnesses and say the formula, "I have expelled you," or "I cast you out." This is expected. This is the odd, lesser-known detail, the piece of evidence that changes the entire investigation. The law was, in this matter, almost perfectly symmetrical. The woman had the exact same unilateral power. She could initiate the divorce at any time for any reason, simply by making a public declaration. We have the records. Let's look at Exhibit C, a papyrus fragment from the workers' village of el-medina, where real people lived, fought, and separated. A woman in a dispute states before the local council, "I am no longer with him. I am leaving his house." That was it. In other cases, the formula was a direct, "I divorce you." This public statement in front of witnesses was the only legal action required. The marriage was dissolved. Let's pause to consider the radical nature of this. An Athenian woman who wanted to leave her husband had to beg her male guardian to file a petition on her behalf and argue her case before a male magistrate, an act of profound public shame. A Roman woman, for much of the Republic's history, was legally trapped. The Egyptian woman, by contrast, held the power of her own freedom. She did not need to prove fault. She did not need to allege cruelty, adultery, or neglect, although these accusations often surfaced later when it came time to divide the assets. The act of divorce itself required only her will and her voice. This was not a hollow right. It was not a legal fiction that existed on papyrus, but was never used. The reason we have so many of these records is precisely because women were using this power, and the men they left were often dragged to court to deal with the consequences. Historians still debate whether the social reality was as clean-cut as the legal one. Was a woman who was economically dependent on her husband's daily wages, or who had multiple small children, really free to just walk out? Or did social pressure and the practical, terrifying reality of finding shelter and food make this legal right a power of last resort? The evidence suggests the threat alone was a powerful negotiating tool within the marriage. A husband knew at all times that his wife was not his property. She was an independent citizen who was choosing to live with him. And if she chose to leave, the law would not stop her. In fact, the law would then turn on the husband with a financial vengeance. Her power to leave was backed by something far stronger than social custom. It was backed by silver. The simple act of her walking out the door triggered an immediate and often punitive financial reckoning. The public declaration we investigated in Section 3, that simple unilateral statement, "I divorce you," was not an emotional outburst. It was a legal trigger. It was the key that unlocked the cold economic machinery of the marriage contract, the prenup we filed as Exhibit B. The moment that declaration was made, the case moved from a social dispute to a financial reckoning. The common fact is that the central complication of an Egyptian divorce was not morality, but math. The court's primary interest was not in why the marriage failed, but in how to untangle the two separate economies that had been operating under one roof. The first, non-negotiable step was simple. The woman's shin, or dowry, that itemized list of goods she brought into the house, was returned to her in full. Every bronze mirror, every linen tunic, every chair, they were hers, and they left with her. But this is just the beginning. The odd, lesser-known detail, the one that truly defines her power, is what happened next. We now submit Exhibit D, the compensation clause. This was, in essence, a termination fee, a penalty. The legal papyri, particularly from the late period, are explicit. If the husband initiated the divorce, if he was the one who said, "I cast you out," he owed his now ex-wife a significant fine. This was not alimony. This was not child support, which was a separate obligation. This was a one-time punitive payment. The contracts often specified the exact amount. If I divorce you, I shall give you 10 deben of silver. This was a massive sum, potentially years of wages for a common laborer. This clause acted as a powerful financial deterrent. A man could not simply discard his wife for a younger woman without facing potential economic ruin. Now, what about the symmetry? What if she was the one who initiated, the one who declared, "I divorce you"? The law was often balanced, but with a crucial favorable twist. If she left him, she might also owe a fine. But the contracts show it was often half of what he would have owed her. In many other cases, her penalty was simply to forfeit the SP, that nuptial gift he had given her at the wedding. She would still walk away with 100% of her own dowry. She was never left destitute. And then there was the third pot of money. What about the property they had acquired together during the marriage? This is perhaps the most shocking concept of all. The law recognized joint property. We have the famous case of Naunachte, a woman from el-medina who wrote a will disinheriting some of her children. In her will, she meticulously details the property she and her first husband acquired together and how it was divided. 2/3 for him, 1/3 for her. The fact that a woman was legally entitled to any share of the family business rather than just her own initial capital is an idea that would not surface again in the West for nearly 3,000 years. Historians still debate the true motive behind this financial framework. Was this a genuinely progressive system designed to protect the woman's autonomy? Or was it a cold, patriarchal calculation by the woman's father to protect his family's wealth? A way to ensure his son-in-law couldn't just seize the dowry and expel his daughter? Was this about protecting women or protecting property? The court records, however, show the effect was real. We have case after case of divorced women suing their ex-husbands for the fine they were owed and winning. The woman who left her marriage did not become a social outcast. She did not return to her father's house in shame. She walked away as an independent, legally protected citizen. And crucially, she walked away with her capital. She was free to remarry, to live alone, or, as we're about to see, to enter the marketplace as a businesswoman in her own right. We have now established that an Egyptian woman could enter a marriage with her own legally protected capital, and she could leave that marriage not as a destitute outcast, but as a financially solvent individual. This is where the file opens onto a world that seems almost impossible. What did she do with that capital? The answer is not just survive. The answer is compete. The common fact, the one we see in all the official art, is that Egyptian society was an agricultural and bureaucratic machine run by men. Men are the scribes, calculating the grain tax. Men are the farmers, driving the oxen. Men are the overseers, the priests, and the soldiers. The public-facing economic and political world of ancient Egypt, as depicted on its own monuments, is almost exclusively male. This is the story they told about themselves, the one that reinforces the subservient shadow myth from Section 1. But the legal papyri, the contracts, the court disputes, the private letters, tell a completely different story. They reveal the odd, lesser-known detail. This official male-dominated picture is a fabrication. It's propaganda. The reality, preserved in the ink of everyday transactions, is that women were fully fledged, independent, and often ruthless players in the Egyptian economy. Let's submit Exhibit E, the business contract. We have a vast collection of these. We have deeds of sale for land. We have loan agreements for silver and grain. We have rental contracts for donkeys and property. And the names on these documents, as buyers, as sellers, as lenders, are just as often female as they are male. A woman could, in her own name, buy a plot of farmland, the primary source of all wealth in the ancient world. She could then lease that land to a male farmer, collect the profits from the harvest, and take him to court if he failed to pay. And she did this all without a husband or male relative as a co-signatory. We have records of women inheriting their father's or husband's entire estate, not just as a caretaker for a son, but as the sole new owner. She would take control of the family farm, the livestock, the servants, and the family business. We have records of women running businesses. The most common was textile production, a traditional female domain, but scaled up to an industrial level. A woman could be the proprietor of a weaving workshop, managing a staff of workers and fulfilling contracts for linen. We even have evidence of women operating breweries. But her power wasn't confined to women's work. We have the famous case of Lady Chat, who was recorded as owning a lease on a ship, suggesting she was involved in the high-stakes, high-profit world of Nile transport. Historians still debate whether this extraordinary legal and economic power translated into genuine social or political power. Did a female landowner, a boss, who employed male laborers, command the same social respect as her male counterpart? Or was she seen as an anomaly, a necessary exception who was still expected to be silent and demure in public life? The official art, remember, is stubbornly silent. We do not see statues of Lady Chat signing shipping manifests. We see her as a mistress of the house, standing dutifully behind her husband. This creates a profound disconnect. The law, it seems, gave her the rights of a man, but society may have still demanded the posture of a shadow. The papyra show she was a citizen at the bank and in the courtroom. The tomb paintings show she was a wife in public memory. This paradox is at the heart of the file, but this system of equality, as radical as it was, had a limit. It had a brutal, non-negotiable exception where every scrap of her legal and economic power, all her citizen rights, vanished in an instant. We have spent this entire case file building the profile of a citizen, a woman with a legal and economic identity so robust, so independent, that it rivals our own. Remember her portfolio from Section 2, her protected dowry, the silver he paid her, the joint property she was entitled to. Remember her power from Section 3, her right to unilaterally declare, "I divorce you." Remember her business acumen from Section 5, the woman who could buy land, run a business, and sue a man in court. This entire legal framework is built on a stunning, anomalous principle of equality. And this is the moment in the file where that entire framework shatters. There was a line, a single, brutal exception, where the law's symmetry, its fairness, and its protection did not just bend, it evaporated. The common fact, of course, is that adultery was considered a grave moral and social sin. This is not unique to Egypt. It's a near universal taboo in ancient societies. The Instructions of Ani, a moral wisdom text, warns a man, do not go near a woman who is a stranger, a deathly crime. The offense was seen as a destructive force that could unravel the fabric of a family and, by extension, the state. But the odd, lesser-known detail is the terrifying asymmetry of the law and practice. This is the great paradox of our file. The law did not treat male and female adultery as the same crime. In fact, it barely treated male adultery as a crime at all. For a husband, infidelity, particularly with an unmarried woman, a servant, or a prostitute, was often a social indiscretion. It was not a matter for the state. If he was caught, the legal consequences were almost entirely financial. His wife, as we've established, had the absolute right to divorce him. His infidelity would be the reason for that divorce, and he would then be forced to pay her the full divorce fine and return all her property. He was punished economically, but not criminally. For the wife, the law was something else entirely. For her, adultery was not a private dispute. It was a capital crime against the state. The moment a woman was credibly accused of adultery, her citizen status, with all the rights we've just detailed, was considered null and void. She lost everything. She lost her right to her dowry. She lost her right to the nuptial gift from her husband. She lost her share of the joint property she had spent years helping to build. She was, in an instant, made destitute, and that was the merciful part. The legal and moral texts describe punishments that are shocking in their ferocity. A text from the New Kingdom suggests the punishment should be death by burning. Other accounts describe mutilation. The woman's nose would be cut off to mark her as a social outcast for life. The most famous literary example, The Tale of Two Brothers, has the husband kill his unfaithful wife and feed her to the dogs. While this is fiction, it reflects a society that viewed this one specific act as the ultimate transgression deserving of a final, dehumanizing penalty. Historians still debate whether this brutal double standard was purely about male power, a simple patriarchal need to control female sexuality, or if it was a cold economic calculation. Was this savagery a defense, not of a man's honor, but of his property? The entire legal system we've admired was built to protect property and ensure its orderly transfer to the next generation. A woman's infidelity was the one thing that could destroy this, introducing an illegitimate heir into the bloodline, a stranger who could potentially inherit the family's land, the business, the very wealth that all those papyrus contracts were designed to protect. This paradox is the dark heart of the file. Egypt could build a legal system that saw a woman as an economic equal, a business partner, and an independent citizen. But it could not, or would not, tolerate the one act that threatened the male's certainty of parentage. In every area of the law, she was his equal. In this one, she was his property. The common fact, the one that closes the textbooks, is that this unique Egyptian civilization eventually ended. It was conquered by the Persians, then by the Greeks under Alexander the Great, and finally, it was absorbed by the Roman Empire after the death of Cleopatra in 30 BC. We know this history. We accept that its unique religion, its pharaonic traditions, and its monumental art style all vanished, replaced by Hellenistic and Roman culture. But the odd lesser-known detail is that this was not just a political or military conquest. It was a legal one. The incoming conquerors, first the Greeks and then most definitively the Romans, did not just replace the pharaoh. They actively dismantled and overwrote this entire 3,000-year-old legal framework. The Roman governors arrived in Alexandria with their own laws, the very patria potestas, the father's power, that we discussed in Section 1. They looked at the Egyptian system, where a woman could own land, sue a man, and hold her own capital, and they saw it not as progressive, but as a barbarian anomaly. It was actively erased. The independent legal citizen status of the Egyptian woman was methodically replaced with the Roman model, where she was once again a perpetual minor, a subservient shadow under the full legal control of her husband or father. The rights we have just investigated did not slowly fade. They were extinguished. This leads us to the final central question of this entire case file. Historians still debate why. Why did this radical system of equality exist in the first place, and only in Egypt? Was ancient Egypt a secret, progressive, feminist utopia? Did this framework spring from a profound moral or philosophical belief in equality? The evidence, frustratingly, says no. We find no great philosophical texts from Egypt arguing for the rights of women. What we find are just contracts. The leading hypothesis is that this entire system was a practical, almost accidental quirk of their legal thinking. Their law was built to obsessively track, tax, and transfer property. It simply did not care about the gender of the person who held that property. A citizen was just a unit of economic activity. And this cold, bureaucratic, gender-blind indifference is what accidentally created a framework of equality. Coda. Let's close the file. We return one last time to Exhibit A, the statue of Menkaura and his queen, the image that sold us the subservient shadow myth. We see her with her arm around his waist, the perfect, supportive wife. But we see her with new eyes now. We see a legal citizen. We know that her arm is not just a gesture of affection. It's the arm of an equal partner. We know she may have owned the ground they are standing on. We know she came into this union with an ironclad prenup, Exhibit B, that protected her assets. We know she held the unilateral power to walk away, Exhibit C, and demand financial compensation, Exhibit D. We know she could have run her own business, Exhibit E, to rival his. This was not a perfect system. It was a profound paradox. It was a world that gave her the power of a CEO, but as we saw in Section 6, could sentence her to death for adultery. It was a legal framework of cold economic equality, not necessarily a social one of heartfelt respect. But it existed. For 3,000 years, this anomaly in the desert provided a level of legal and economic freedom for women that would not be seen again on this planet until, in many countries, the 20th century. The true tragedy of this file is not just that this system was lost, it is that it was not a stepping stone to our modern world. It was a dead end. The Greeks and Romans who followed did not learn from it. They annihilated it. They buried the Egyptian woman's legal identity under their own, far more oppressive, patriarchal laws. This case proves that history is not a simple forward march toward progress. Sometimes it is a brutal retreat. And for the women of the ancient world, the fall of Egypt was not just a change of flags. It was the closing of a door that would stay locked for 2,000 years, 1,000 years, 1,000 years, 1,000